From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. I won't try to find the exact line between public rights and private rights, but it might be illustrative. What the SEC is using as an example of a public right is patents. A patent is a grant from the government, and what the SEC is saying is that under Supreme Court precedent, that does not necessarily require a full Article III federal court or Seventh Amendment protection for a jury. So there are administrative patent judges that decide cases in the patent trial and appeal board, and the SEC's argument is that that's okay, that's fine. That the government patent is a grant from the government. No one has a right to a patent. The government can set up rules for what is required of a patent, how those patents are adjudicated if there are disputes, two people claiming a patent for one invention or something like that, that can perfectly well go through these kinds of administrative judges. But Kim, to the point that Alicia was making for the break, my understanding here is that Mr. Jarkissi is facing a $300,000 penalty and an order barring him from the industry. And I have a hard time seeing how that is analogous to whether your patent granted by the government is valid or not when another party comes to dispute it.
Right. I mean, let's talk about what he's actually accused here of doing. He's accused of securities fraud, meaning specifically in his case, he's accused of inflating the value of fund assets, which allegedly therefore allowed him to earn higher management fees. Those fees were taken from or extracted from other private individuals. So he is essentially charged here with having committed fraud as a private individual against other private individuals. None of this, in my mind, is what you might call a specifically government-granted right. When I think of that, I mean, you used the patent example, but let's say you were talking about an asylum claim in which the federal government granted you asylum, or you're talking about certain veterans' benefits that are bestowed by the government on individuals who served the government in a fighting capacity. Those are the distinctions that are being argued in this case. Now, the SEC obviously wants to try to define a public right as anything, saying that anytime it sues, quote, on behalf of the public, i.e. any individual, that therefore it has the right to do so. This is a public right. That's an extraordinary, expansive definition, and also one that has no limiting principle either. And I think, those are things that judges care about deeply, this question of where is the line? And it's often when agencies end up wrapping themselves in knots when they don't have a good answer for that. And it strikes me here that this particular definition, suing on behalf of the public, is so expansive to cause the SEC real problems in this case.
Alicia, what are the stakes here if Mr. Jarkissi wins? Because as is usual in these administrative law cases, this is being presented in some quarters as the one thread that is going to get pulled and it's going to unravel everything that's going on in Washington. And that may sound like an exaggeration, but here's one headline: complex Supreme Court case could have devastating results. And special mention to the Atlantic magazine, the case that could destroy the government. So, Alicia, can you cut through this and give us a sense of what are the real outcomes that are at stake here?
It really actually depends on how broad and expansive the court's ruling is, and in terms of actually delineating also between public and private rights. But a mere ruling for Mr. Jarkissi would just mean that at least the SEC would have to go to an actual federal court to prosecute fraud claims. That doesn't mean that it would have to go to a federal court to prosecute all kinds of offenses under the security laws, but it would have to do so at least for fraud. And you can imagine that would probably also be true for the FTC when the FTC wants to claim that a business is essentially defrauding customers. It would probably have to go to a federal court as well instead of trying these cases internally. Of course, those kinds of cases would actually have to be broader. The challenges to these enforcement actions would actually have to be brought by plaintiffs when they are charged by these agencies. And the federal courts would apply the precedent, and they may not always come out on the same way. And there's a lot of blurriness in terms of just, again, how expansive the court does come out. because there's actually 1977 precedent, Atlas Roofing. It was a unanimous decision, actually, that upheld OSHA's use of essentially eternal tribunals to enforce wrongdoing by employers' workplace health standards. And I don't think you're going to have the court to actually overturn Atlas Roofing. It has been actually narrowing that decision in recent decades and chipping away at it. And you may see that again here. So there's still going to be a lot of ambiguity about some other kinds of internal in-house processes that a lot of agencies, and again, these are just rife across the federal bureaucracy. Elon Musk has actually brought a challenge on behalf of SpaceX in response to an administrative complaint that the Justice Department brought against his company for discriminating against asylum claimants. And you're actually starting to see more and more of those challenges to these in-house internal tribunals. So I think that would probably be the biggest implication of this ruling. It would probably embolden defendants to bring constitutional challenges to these processes.
But the end result of that would be agencies having to go through the federal courts instead of their own courts, which I understand would be pretty inconvenient in many cases for those agencies. But Kim, that is the whole point of these protections that are in the Constitution. I can think of all sorts of rules that are quite inconvenient for people trying to enforce the law. The beyond a reasonable doubt standard for convicting someone of a criminal offense. Boy, wouldn't it be nice for prosecutors if it were a lower standard of evidence? The exclusionary rule, the rule that under which evidence, for example, that is gotten through an illegal search is excluded from criminal trial. Boy, isn't that inconvenient when you're trying to put bad guys behind bars? But this is how the system works. And I think that's why our founders put these kind of constitutional protections in the Seventh Amendment and the separation of powers in the first place. And if the result is more cases going to federal court, then maybe we need more federal judges and staff to deal with that. But I don't think the answer is to cut the corners so that it's easier for the SEC or these other agencies to fine people without the due process that they're entitled to under the Constitution.
Yeah, I mean, boo-hoo for these agencies and prosecutors that they might have to work a little harder. Guess what? It's supposed to be hard. You begin with the presumption of innocence, and the bar for bringing a case and successfully proving it should be very, very high. And this is why those stories and headlines like the ones that you read, Kyle, just drive me absolutely nuts to suggest the sky is going to fall if we, in fact, return to a day that is far more in keeping with the long history of the United States. The reality is that the anomaly here is this administrative state that in recent years has grown into this unrestrained behemoth. In part because of the size of it, in part because of congressional legislation that has turbocharged it, like the 2010 Dodd-Frank rule that set up this whole system that allows the SEC to act as a law unto itself, in part because of civil service protections that make it impossible to get rid of these people, and in part because of Democratic administrations that are constantly pushing the boundaries and getting its administrative staff to do things that no one has ever done before that really are egregious in terms of sort of standards and protocols. So the anomaly, again, is that situation and how offensive it is, even though it happens sometimes in creeping form, to bedrock protections that are in the Constitution. And not to get all foundery here, but, you know, one of the reasons we have the Seventh Amendment is because Britain used to like to punish colonists and religious dissidents by using admiralty courts and imposing civil penalties on them, for instance, failing to abide by the Sugar or the Stamp Acts. And this was extremely offensive to the early colonists. The Declaration of Independence said that one of the grievances here was a lack of a trial by jury. And it's why we have the Seventh Amendment in the Constitution. So yeah, it's supposed to be really hard. And we have migrated to a system where everything is now stacked on behalf of the administrative state. And I'm hopeful that actually the Supreme Court doesn't rule narrowly. I hope that it really tries when it has an opportunity like this to clear the decks and let us go back to a situation where the government is restrained and it has to jump through all kinds of hoops if it wants to come after you, impose sweeping penalties, and also bar you from your own profession.